Hello everyone, Jai Hind and welcome to the platform of Shri Ram's IAS, and in today's session in Polity in 20 minutes, we'll be talking about governors of the state. Alright, so the original constitution of our, India, that provided that there shall be a governor for every single state. But later on, after the 7th Constitutional Amendment Act, which did the state reorganization. So after that, it was decided that two states two or more states that can have a single governor as well. All right, and that has been decided by the 7th Constitutional Amendment Act. Now, we'll be talking about the constitutional provisions about the governor of the state in today's session, but at the same time, do not forget this, that if you are encountering any kind of problem or any kind of doubts in your preparation for your civil services, so you can reach out to us at Shri Ram's IAS. And for this, what you need to do is you need to fill out a Google form that is given in the description box. And ultimately, our trusted mentors, they will get in touch with you and they will guide you throughout your preparation for the UPSC exam. All right, now coming back to the governor of the state, when it comes to the constitutional provisions. So the provision of the governor of the state is given under Part 6 of the Constitution between Articles 153 to 167. The governor is in the same manner as the President of India, but at the same time, the role and the functions of the governor are limited to the state to which he is the governor. Alright, he is the executive authority, or all the executive actions are taken in the name of the governor for the state. That is, he is a nominal head and ultimately nominal executive head of the state. Alright, it mirrors the union presidential system that we have. We can connect, or we can think about, or that is what exactly you should do, and that is you should have a comparison of governor along with the president as well, because that is how the UPSC likes you to think about it. All right, and ultimately we have taken the British parliamentary model, and this has the roots in the British parliamentary model itself. Now, when it comes to the position of the governor is just like the President of India, and that is, he is the constitutional head of the state, and all the functions are performed in the name of the governor in the state. At the same time, he is de jure executive, just like the President of India, that is, he has a formal authority under the law, but at the same time, the actual or the de facto power vests with the Chief Minister and the Council of Ministers. Alright, so ultimately the governor, he is the head of the state and he acts as a bridge between the center and the states that we have. These are the articles which are related to the governor. We have Article 153 that deals or the states governors of the state. Then we have Article 154, executive power of the state. 155 that deals with appointment of the governor. Then we have 156 that deals with term of office. 157 and 158 that deals with qualifications and conditions of the office. 159 is oath to the office. 160 is the contingency provisions, and 161 we have the pardoning powers of the governor, just like we had the pardoning powers of the President of India under Article 72. And then we have 164 and 163, that is Council of Minister and the appointment of Chief Minister. And then we have 166 and 67 that deals with conduct of business and the Chief Minister's office. Now, when it comes to the appointment of the governor, a governor is not actually elected. Just we have president who is elected, but governor is actually appointed under Article 155, and he is appointed by the President of India. And this is indirect appointment system and ensures the national integration as well. He is not elected, and this avoids the state level politicization. But at the same time, appointment process, it often reflects the central influence rather than the genuine state consultation that should be there while appointing the governor to the state. When it comes to the qualification, as per Article 157 and 158, the basic qualification is that he must be citizen of India and also must have completed 35 years of age. At the same time, there are certain disqualifications. He cannot hold any office of profit, he cannot be a member of parliament or any state legislature, and must vacate such membership if he is appointed as the governor of the state. Now, the term of the office has been specified under Article 156, and it says that the term of office is 5 years term. But however, the governor holds the office as per the pleasure of the president. Alright, he holds office during the president's pleasure. That means the president have over here he has the complete right to remove him at any point of time or to transfer him to the another state or give the additional responsibility of any state. So he can be removed or transferred anytime, and that gives the flexibility to the tenure of the governor, and he is eligible for the another term as well. Over here, Sarkaria Commission had recommended that the removal should occur only for a valid and rare reasons to protect the federal spirit that is given under the Constitution of India. Now, what are the conditions of the office? So, when it comes to the official residence, he is entitled to Raj Bhavan and the staff support. There are fixed emoluments. Over here, you must remember that these emoluments or the salary, it is determined by the parliament, and over here, it is charged on the consolidated fund of the state. Alright, not to the government of India, but to the consolidated fund of state. However, the salary and emoluments, they are decided by the parliament. So, he gets the fixed emoluments, and if he acts as the governor for more than one state, alright, then that salary does not get doubled. Suppose he is a governor of two states. So, the salary does not get doubled, but the salary is actually divided into a set ratio between both the states. So, he will get only one salary even if he is a governor of two states. Alright, and he must not engage in other professional or business activities, and these provisions, they ensure the dignity of the post of the governor as well as neutrality and the independence of the constitutional office of the governor. Now, when it comes to the oath of the office or oath of the governor, it is given under 159, and over here this is administered by the Chief Justice of the State High Court, concerned State High Court or any other. If the State High Court Chief Justice is not there, so senior most judge that officiates, and ultimately the oath is the oath is provided for the allegiance to the Constitution. Alright, that he has the faith and allegiance to the Constitution of India, to uphold law and constitutional order, and that he is dedicated to the service of the people of the state. Now, what are the powers of the Constitution? So, of the governor. So, just like president's power, we have different powers. We have executive power under 154 to 160 articles. We have the legislative powers of the governor under 168 and 212, and then 161 that provides for judicial power, and discretionary power are given under Article 163 of the Constitution of India. Now, when it comes to the executive powers, he is the head of the state executive, and all executive decisions of the state, they are taken in the name of the governor of the state. At the same time, he makes key appointments, just like the President of India. So, he appoints the Chief Minister. He also appoints other ministers on the advice of the Chief Minister. He appoints Advocate General of the State Election Commissioner, and even the members of the State Public Service Commission are appointed by the governor. Alright, at the time of the President rule, he directs the administration under the Article 356. So, these key administration or the appointments are made by the governor of the state. When it comes to the legislative power, again he has a similar power as that of the president. That is, he has a legislative control where he summons, prorogues and dissolve the state legislative assembly, and at the same time he cannot dissolve the state legislative council because that is a permanent house, just like we have Rajya Sabha. Alright, he also addresses the first session after the election of the state legislative assembly, and also annual sessions. Your first annual session is addressed by the governor of the state, where he outlines the government policy, as well as he may assent, withhold or reserve the bill for the president as well. And there is, for the nomination as well, he nominates 1/6 members of the legislative council of the state, where we have bicameral legislature in the states. When it comes to the pardoning powers, he also have the pardoning powers as per Article 161, and he may grant pardon, reprieve, remission or suspension of the sentence, just like we have studied in the case of President of India. Alright, just the case. But however, there are certain restrictions. Alright, it excludes the death sentences. There would be no death sentences that will be pardoned by the governor. And also, when it comes to the pardoning power, they are where the state law is involved. Alright, where the state law is involved, and he cannot pardon the death sentence, or or even the court martial. All right, they cannot be pardoned by governor, because over here for the death sentence and court martial, president have the exclusive pardoning power. All right, and he can also consult the state high court on the appointments to the judicial, subordinate judiciary. So ultimately he function as the constitutional mercy authority at the state level, just like we have the President of India. Then we have the discretionary power that is mentioned under Article 163, and over here he can act on his discretion without the advice of the Council of Minister, and that is when there is hung assembly. So in the event of hung assembly, he may select the chief minister when there is no clear majority. All right, when there is loss of confidence, he may dismiss the chief minister if he has lost the majority in the legislative assembly, and also he may reserve the bill for the president's consideration. He can also recommend the invoking of Article 356 if the state machinery had a constitutional breakdown. And also, when it comes to the discretionary power, he has unique duties in certain states, just like we have Nagaland or formerly Jammu and Kashmir. Now, these discretionary power are basically the most debated and controversial dimension of the governor's role in the Indian polity setup. Now, governor also acts as a bridge between center and the state. He submits annual reports to the president on the state governance, also reports the breakdown of the constitutional machinery under Article 356, and also ensures implementation of the union laws into the state, and maintains a dialogue between the governments, and acts as a source of communication between state and the center. So he acts as a constitutional safety valve in the Indian federalism. All right, there are certain controversies and reforms as well when it comes to the post of the governor. The controversies or the issues are that there are partition appointments. Partition appointments, the people who are, they are allegiance to, or they have, direct links with the central government. They are appointed as the governor, and ultimately because of the partisan appointments, that undermines the neutrality of the post of the governor in the states. There is also misuse of discretionary powers that I have told you. That is the most debated topic. Then there are frequent removals or transfers as well. There are delay in assent to the bills and political interference in the state affairs as well. Now, this is very, very important because recently Supreme Court have given its, under Article 143, Supreme Court have given its verdict on this particular thing, that delay in the assent of the bills. So this again is a current topic, and ultimately the complete chapter on the governor becomes important for your UPSC examination. Now, Sarkaria Commission and M.N. Punchi Commission were appointed, and these commissions were basically for the center and state relationship, where they made certain recommendations for the post of governor. The Sarkaria Commission made the recommendation that there should be consultation with the Chief Minister before appointment of anyone as a governor. Alright, there should be use of discretionary powers that should be used very sparingly and only in the conditions where they are very much needed. And also, he said that there should be the respect for the federal principles that are there in our Constitution of India. At the same time, M.M. Punchi said that there should be a fixed term of 5 years that should be provided to the governor, and this protection should be provided for anybody being appointed as the governor. Please remember, these are the recommendations. Alright, and then the code of conduct should be there for the governors, as well as the limited role during the hung assemblies should be provided to the governors. Now, there are certain landmark Supreme Court judgments where the judiciary have progressively redefined the governor's limits as well as accountability. In Shamsher Singh versus State of Punjab in 1974, court said that the governor acts on the Council of Ministers' advice except where the discretion is explicitly mentioned in the Constitution. And in S.R. Bomai case in 1994, it was said that the presidential rule, that is where the governor acts solely on the advice of the central government. So in the event of the president rule, that is subjected to judicial review. Ultimately, that have limited the misuse of Article 356 in India. And then in Rameshwar Prasad versus Union of India in 2006, it was said that dissolution of assembly based on the governor's report, it can be judicially reviewed. And then in Namam Rabia versus Deputy Speaker in 2016, it was said that the governor, he cannot interfere in the legislative proceedings and he must act constitutionally. So over here you will see that the governor's role, accountability had been limited by the judiciary and various cases progressively. Over here we can do a comparative perspective. We can see in the comparative perspective the governor that is there in the provinces or the states in US and UK as well. In India, he is the head of the state and the governor is appointed in India. However, in USA, he is elected. In the UK, he is just a monarch's representative. At the same time, when it comes to the tenure, in India it is 5 years. However, he holds the office during the pleasure of the president. In USA, it is a 4 years fixed term, but at the same time, in UK, he is at the monarch's pleasure, just like in India. There is limited but significant discretionary powers which had been provided in India. However, there are no discretionary powers when it comes to the role of the governor in USA or UK. And then in India, he is nominal as well as he acts as a federal link between center and states. But at the same time in USA, he is real head of the state, and in UK, he is just a ceremonial head of the state. Alright, so ultimately, when it comes to the role of or the post of the governor that is there in India, we have taken a hybrid model where it is British ceremonial tradition that we have accepted along with the federal watchdog function, that is the hybrid function or hybrid model of the governor that we have adopted. So ultimately, when it comes to the role of or the post of the governor, it is crucial and symbolic. He is a symbolic head, but at the same time, he acts or functionally crucial to the federal equilibrium, and sometimes he acts as as an agent of the center that had been set by various state governments in the past. Also, there is or he must act as a constitutional referee, but not as a political player. It has been said that the governor should not be politically inclined and he should be politically neutral. Alright, and in the words of Dr. B.R. Ambedkar, the governor is expected to follow the advice of the ministers, but he must act as the guardian of the constitution. So I guess now you have a complete idea about the role of the governor in India as per the Constitution of India. So that would be all in this video. We will see you in the next. So till then, take care of yourself, apna dhyan rakhein, and plus do not forget to like, share and subscribe this video. Thank you. Bye-bye. Take care and Jai Hind. Thank you.